We will now open the hearing on Senate Bill 460. Senator Flowers, would you like to open on your bill?
Thank you, Mr. Chair. My name is Pat Flowers. I represent Senate District 31 and come before you today with Senate Bill 460. Mr. Chair, members of the committee, this bill tries to right a wrong that was imposed on the people of the state that find themselves with a proposal to build a large gravel mine next door to their property. Gravel mines bring with them many concerns for neighboring landowners in rural areas of the state, including road dust, truck traffic, noise, and in this case, water impacts. We obviously need gravel, but we also need to protect everyday Montanans who have a home in an area of a proposed gravel operation. We need balance in how we address this, and I believe we don't have that right now. In 2021, we passed a bill that tipped the balance to favor gravel pit developers at the expense of the homeowners in an area. Senate Bill 460 attempts to correct one of the issues that many consider to be their most important concern with the changes in the 21 law, their ability to protect their water. Prior to 2021, the law required the state to consider water resources prior to issuing a mining permit for an open cut operation. Specifically, the law previously required that surface water and groundwater be given appropriate protection consistent with state law. SB 460 reinstates that language for both types of permits that were created in 2021. The standard permit and the high and dry permit, which isn't actually required to be high and dry, it could be considered high and dry even if there is water present, but if there's less than 10 residential property owners nearby. So why do we need this? Because currently, most gravel pit mining permits have no site-specific analysis for water resources. That means the public does not know how an operation may impact their wells and water quality. The public cannot provide any data regarding site-specific water resources, and DEQ cannot make decisions that protect water resources. And this issue has come to my attention through two different circumstances, one within my district and one just outside. The one outside, you'll hear about in a little bit, had specific considerations for water quality in the previous evaluation of this permit, but because we changed the law, suddenly it was okay to move forward despite those same concerns remaining. We'll hear more about that. DEQ told the committee in 2021 that water analyses would still occur in the water discharging permit process at DEQ, so eliminating it from consideration in the gravel pit context would have no impact. But that has proven untrue. Water quality is rarely considered in open cut permitting, and there's no longer any consideration of water quantity in the permitting process. Most troubling, there's nowhere in the process that requires analysis for water quantity impacts, which are generally people's important concern. How will this mine next to my property that's digging down or below the water table affect my well? That means that people who have a mine proposed next door have no idea of the impacts on their water quantity. This has left landowners with nowhere to turn except the courts, clogging the Board of Environmental Review and district court dockets across the state. Currently, there are 5 active lawsuits related to open cut permits. That number of legal challenges, in my mind, suggests that we got it wrong when we changed the law in 2021, and we need to correct that. Thank you for listening to my opening, and happy to answer questions. Thank you.
Thank you. Proponents.
Mr. Chair, committee members, my name is Gayla Nicholson, G-A-Y-L-A-N-I-C-H-O-L-S-O-N. I have a map of the site I'm going to be talking about today. May I submit?
If you'd hand it to the secretary, please.
I support Senate Bill 460. This is a dry land open cut mine that was permitted for the project near Seeley Lake in April 2023.
If you could pull the mic a little closer, please.
Yep.
Thank you.
This is a dry land open cut mine that was permitted for a project near Seeley Lake in April 2023 on DNRC trust land. The mining company already had bid on this pit and in the previous January, so it was not needed for the Seeley Lake project. My property and well are located between the mine site and the Clearwater River, about 800 yards from the southwest corner of the site. The mine sits on a terrace about 100 feet above the river, and I'm concerned that the mining operations could contaminate groundwater and surface water in the surrounding land and downhill from the site. The mine is bordered on 3 sides by public land that is managed as part of the Blackfoot Clearwater Wildlife Management Area. On the northern border is a 52-acre parcel acquired by FWP in 2010 to prevent commercial development and preserve winter grazing range, a wildlife corridor, and 1,800 feet of river frontage. To the west and downhill from the mine are lots leased by the DNRC to cabin owners, privately owned lots, and domestic wells. And then 70 feet to the south is what the kids locally called the Turtle Pond, and that's the closest body of water to the site. As part of their application for a mine and asphalt plant, the mining company dug 3 14-foot test pits in 30 days, and that was after the DEQ deemed that the permit application was acceptable. They awarded a permit for a 20-foot deep pit to operate for 17 years. To get the permit, the mining company certified that their operation would not affect ground and surface water. Of concern is that they had gone on record saying that they did not analyze the site for the presence of groundwater. For their part, the DEQ had stated that they did not confirm the mining company's certification about effects on water or perform a hydrological study or require test wells. A senior hydrologist experienced in researching and writing environmental assessments for gravel mines has visited the site and reviewed the permit. Based on his analysis, both the mining company and DEQ were unaware of the depth to groundwater or direction of flow of any water or potential connection to Elbow Lake and the Clearwater River when the permit was issued. Equally troubling is that nearby property owners have observed large quantities of dust produced by heavy equipment during mining activities that drift to the east and drop onto the surface of Elbow Lake. An appeal for this permit is pending before the Board of Environmental Review, asking for clarification whether this site is truly high and dry. The BER has met once since August, and their next planned meeting is scheduled for April. With 2 of the last 4 meetings canceled by the BER, the appeal is pending after 22 months. I believe the DEQ should evaluate potential impacts to ground and surface water at sites like these accurately, using industry standards and without shortcuts before issuing a permit. In this case, the DEQ took a month to issue a permit, and it will take 2 years before the BER decides if they got it right or not. The due diligence and proper evaluation should have been done up front. Per their website, Montana DEQ is here to serve you and ensure Montanans have clean air, water, and land free of contamination. Please pass SB 460 so the DEQ can do its job.
Thank you. Further proponents?
Mr. Chairman and members of the committee, my name is Ruth Angeletti, A-N-G-E-L-E-T-T-I, from Gallatin Gateway. Thank you for the opportunity to speak. Gallatin Gateway is a vibrant community, not what some expect as they drive by at high speed along Highway 191. Neighbors help neighbors, community center gatherings, blood drives, scholarships for local kids. Gravel pits can unravel a community such as ours. We know that wells can be compromised by lack of consideration of water issues. Friends adjacent to the Nuss pit had their well go dry. A much deeper well had to be dug. Our neighborhood includes multi-generational Montanans, single parents, respected outfitters, a young couple starting a business, a Vietnam War veteran, families dealing with cancer or other chronic diseases. Jeopardizing their water and lives is wrong. It should no longer be possible to overlook a community's right to water, clean and abundant water, when considering a permit for a gravel pit. Please vote yes on SB 460 to reinstate consideration of water in approving mining permits. Thank you.
Thank you. Further proponents?
Chairman, members of the committee, thank you for your time and thank you for the opportunity to testify in front of you. My name is Kristen Corbin, C-O-R-B-I-N. I'm representing myself. I live in Manhattan, Montana. I'm a fifth generation with strong heritage of agriculture and ranching ties. I've lived here my whole life. My family, I'm raising here to be Montanans. We love the values and we want to continue it for our generations to come. I'm here to testify that the permitting process right now has some flaws. I think that Senator Flowers brought that up, that the bill was changed in 2021, and with it was a loss of some of those key things to keep our environment and our communities safe in light of these gravel pits. I've been going through the permitting process for a year and a half. A permit was applied for and accepted beside our subdivision. It is right next to our subdivision and within the half-mile radius of another subdivision. We're all on private wells. Our water table is 8 feet deep underneath our land. The pit is accepted to dig for 40 feet. So they will immediately be in our water table and they will be digging for quite a bit. When we talked to the DEQ about our concerns about water quality and quantity, the DEQ, and I quote, said, "It's not in our purview and our hands are tied by the previous law." There was nothing about our concerns put into the application and the permit that's been approved. We continued to say our concerns. We have historical evidence and anecdotal evidence of concerns of flooding and contamination and of wells being dry and issues with our water. Again, there is nothing in the actual permit to monitor the water right now. Where's the protection of our water table? Previously, this pit was attempted in about 2007. At that time, it was the previous law that we are using, this SB 460 is trying to reinstate. At that time, they determined that the water was a high risk of contamination during that time. The law was changed, they resubmitted their gravel pit, and now they're up and running. I don't understand where the protection of our water table is within that, especially when we're bringing concerns throughout the whole state of water. As you know, the bills this session are talking about exempt wells, our concerns in our water tables, our very important finite resource. Why should an exempt well for a development be an issue in your backyard, but a gravel pit digging in my water table isn't of issue? Where does that stand? Where is the continuity there? If we're worried about water, this is just another piece of the puzzle of water. We know that we need gravel. We're not saying we want to shut down gravel. In fact, I said that last week. We want to work together, but we also want to go in the right direction. Voting yes on SB 460 will help us. It'll bring all stakeholders' interests to the table, not just certain stakeholders. We're concerned about our water. We have no protection of it, and we feel that SB 460 will help us with that protection of our water. In that, I hope that you vote yes for SB 460. Thank you.
Thank you. Further proponents?
Mr. Chairman and committee, thank you. My name is Doug Rand, spelled R-A-N-D. I've lived south of Gallatin Gateway for 55 years. I urge you to support Bill 460 and go back to the law before 2021. In the summer of 2023, our immediate neighbor to the north applied for a state permit to develop a 20-year 130-acre gravel pit 100 feet from our house. During the permitting process, the Montana DEQ asked the applicant in a letter dated October 26, 2023, to assess the behavior of the water table in specific ways. The applicant responded with data from 2 other gravel pits they operated miles away. In the words of a reviewing licensed environmental engineer, this was ludicrous. The permit was granted in spite of the applicant's failure to meet the requirements set by the DEQ. Please, let's go back to the language that existed in the open cut mining law prior to the change in 2021. Please vote yes. Thank you.
Thank you. Further opponents?
Mr. Chair, members of the committee, Ann Hedges with the Montana Environmental Information Center, that's HEDGES, and I made a rookie move. I only have 1 copy of this, and I'd like to just pass it around. Would that be okay?
Yes, we can get it to the secretary to put it in the record.
Mr. Chair, members of the committee, what I just passed out was a map that shows about approximately 1,700 open cut operations on the ground in Montana today. Some of them are being permitted now, but none of them have really ever considered water quantity issues, which is why one person in the Gallatin Valley, we already know, has lost to 23 feet of height in her groundwater. She had to dig a new well. We know these problems occur around the state. The problem is, I was asked this question last week, and I just want to respond to it. How come where are the examples of the problems? Well, first off, DEQ doesn't track water quantity issues. So when a pit goes in next door to landowners, they don't go to DEQ. They have to go through court. They have to deal with the water rights system. They don't have much recourse. And so the landowners who were there on the ground originally are losing their water resources, and they really don't have anything that they can do. Now, prior to 2021, DEQ was supposed to be considering water quantity and quality, and it didn't consider water quantity, and that's why we still have all these problems on the ground today. And when it comes to water quality, DEQ does something called a general permit. Those permits are water discharge permits that they rewrite every 5 years. And as long as a company comes in and says, we will follow that general permit, there's no site-specific analysis on water discharge. So what happens is the public is left in this bind of not being able to comment, not being able to provide any data that DEQ can consider on water resources, whether that's quality or quantity. So you have these open-cut operations, and the neighbors are stuck not being able to talk about the one thing that matters most to them, and that is water. The open-cut law is, the purpose of it is to protect aquatic resources, and yet we are not allowing our agencies to do that, which is why you are seeing so many cases in court today. There is a simple fix to this to keep people out of court, to help people protect their water resources, to allow gravel operations to continue. But right now, we have tipped the balance completely in favor of the developer and against the people who are already there when the developer comes in. I think we can strike a balance here. I think this bill does so, and I would urge your do pass. Thank you.
Thank you. Further opponents?
Mr. Chair, committee members, again, Andrew Gorder, that's Gorder, again, on behalf of the Clark Fork Coalition. I can keep my comments very brief here today. The state already has an affirmative legal duty to ensure that our state's water resources are protected from degradation, that's water quality, and from depletion, that's water quantity. So this bill simply clarifies that open-cut mining projects are not exempt from these existing legal requirements. CFC supports this bill. It's a good bill. I want to thank the sponsor for bringing it. And we need this important clarification to protect both our water resources as well as the property interests and rights of those folks who spoke before me. So we would support this bill. Thank you.
Thank you. Further proponents? Proponents in the room? Do we have any proponents online?
Mr. Chair, here's Clinton Nagel.
Go ahead, Mr. Nagel.
Yes, thank you. My name is Clinton Nagel, president of the Gallatin Wildlife Association. My last name is spelled Nagel, and I'm here this afternoon asking for a pass on Senate Bill 460. We testify here this afternoon for the simple reason that the protection of the state's surface and groundwater resources should be paramount in the application of duties and responsibilities of DEQ. The fact that there needs to be a proposed legislation to put that in writing is utterly unfathomable and yet not surprising. Back in 2021, when House Bill 599 was passed by the 67th legislature and signed into law, a huge mistake was perpetuated upon the good citizens of the state of Montana. How can a state agency that is charged with the mission to protect the state's water resources have such a cavalier approach to water quality issues? It should be the legislature's duty to provide for adequate remedies and the administration to maintain and improve a clean and healthy environment under Article 9, Section 1, and Article 2, Section 3 of Montana State Constitution. This is what Senate Bill 460 will help to restore. You may ask why a wildlife advocacy organization is involved in this legislation. There is nothing more critical to life itself than clean air, clean water, and the abundance of that water. Having a background in the hydrological sciences myself, working for the USGS for 31 plus years, I have seen very little reference or evidence by DEQ that they have considered matters concerning surface groundwater relationships. That is shocking. There must always be a site-specific analysis. DEQ should be a science-based agency that has enforcement power and needs to act like it and make decisions backed by science on behalf of the citizens of Montana. The passage of Senate Bill 460 will help in that effort. Thank you.
Thank you. Further proponents online.
Mr. Chair, here's Libby Langston.
Go ahead, Ms. Langston. Believe you're on mute, Ms. Langston.
Okay, sorry about that. Mr. Chair, members of the committee, my name is Libby Langston. That's Langston. I live a majority of my life at Elbow Lake, a wide spot in Montana's Clearwater River. I've had my DNRC cabin lease site for 27 years. I care about any kind of threat that would pollute the river, including the likely pollution that would result from a nearby potential gravel mine and asphalt plant operation. I am a proponent of Senate Bill 460. This bill would simply require the Department of Environmental Quality to live up to its name and ensure protection of surface water and groundwater in open-cut mining operations. Ironically, I recently read an article in the Seeley Lake Pathfinder that the DEQ is seeking applications for approximately $1 million in funding for non-point source pollution reduction projects. The newspaper article says non-point source pollution is the largest cause of water quality impairment in Montana's lakes and streams, and typically comes from diffuse sources that are not regulated under discharge permit. Non-point source pollution is often associated with a variety of uses, including runoff from abandoned mine sites. The article goes on to say, in lakes, streams, and wetlands, these pollutants can cause harm to aquatic life and can make the water unsafe for human recreation and consumption. The article also says DEQ monitors water quality in Montana's lakes and streams and identifies waters that are impaired. Non-point source grant funding is one way that DEQ helps improve impaired waters across Montana. Mr. Chair and members of the committee, I feel it is much better to prevent water pollution from occurring in the first place rather than having an open-cut mining operation impair nearby water wells and rivers that the DEQ then tries to heal with $1 million+ in grants to try and fix the problems. Please vote yes for Senate Bill 460. Thank you.
Further proponents online.
That is all, Mr. Chair.
Opponents in the room.
Good afternoon, Mr. Chair and members of the committee. For the record, my name is David Smith, SMITH. I'm the Executive Director of the Montana Contractors Association. My members build the roads, bridges, and schools in your communities. The oversight of water quality during the application process and throughout the life of an open cut operation is one of the most closely scrutinized aspects of a gravel quarry. Commenters continually misrepresent how water quality is monitored. House Bill 599 in 2021 removed redundant oversight regulated by other DEQ programs such as the Water Protection Bureau. In other words, it cut red tape. OpenCut does not have the expertise or the resources and must collaborate with other agencies to administer the act. Subject matter experts, if you will. So who's the subject matter expert? DNRC. So that's who we go to now for that part of this. House Bill 599 did not remove or diminish the operator's requirement to address concerns when the operations have the potential to affect groundwater or surface water. I would just remind you that Open Cut is a reclamation act. It's not a water quality act. I was glad to see that there was a picture passed around of the 1,700 gravel permits that are across the state of Montana. Over half of those are owned by counties. They are not under any kind of water quality regulation. Finally, I would just ask you to, I would hope that DEQ will be an informational witness and that they can factually answer any questions you might have as to how many water quality or quantity issues have arisen since 599 was passed. I respectfully request a do not pass for 460. Thank you, Mr. Chair.
Thank you. Further opponents.
Good afternoon, Chair and committee members. I got some documentation I'd like to submit in regards to recommended practices for open cut operations.
Please do.
To go back to David Smith's point, the DNRC is the experts in this. They're the scientists that we should be listening to when it comes to water resources and quality when it comes to open cut mining. That being said, we are and have been following the standards as written and that we have to provide during the permit process. There's a lot of different things that happen in the permit process, and I'm not an expert at every single one of them. That's why you would have someone like the DNRC provide you and make sure you're giving them the accurate information and they can relate that information to process the permit. TMC's been mining in Gallatin Valley since the early 90s, and I can testify to a fact that the current Black Pit and Gallatin Gateway, as the permit reads, we will not be mining in the water at all. So there will be no problems as far as disrupting groundwater at the Black site in Gallatin Gateway. That is a fact, and it is in the permit. As far as water tables that have been, or wells that have been dried in Gallatin Gateway, there is no physical evidence that that was because of a gravel pit, none whatsoever. So it's another one of these we can say what we want and hope it sticks to the wall. Again, TMC's been mining in Gallatin Valley since the early 90s. Several locations, not once is there any evidence that we dried up a well or contaminated drinking water. Not once in over 30 years. I'm here to oppose 460, and I hope you do as well. Thank you.
Could you please state and spell your name, please?
I apologize. Ken Murphy, M-U-R-P-H-Y.
Thank you. Further opponents.
Mr. Chairman, members of the committee, John Iverson. I'm with Treasure State Resources Association. Treasure State Resources is a broad coalition of mining, agriculture, transportation, timber, all forms of energy, oil and gas, recreationalists, organized labor, and construction. I won't cover the issues that have already been covered, but just say that the broad coalition also supports this bill. Thank you.
Thank you. Further opponents. Further opponents in the room? Do we have any opponents online?
Mr. Chair, here's Cale Fisher.
Go ahead, Mr. Fisher.
Good afternoon, Mr. Chair and members of the committee. My name is Cale Fisher, C-A-L-E-F-I-S-H-E-R. I'm the project manager for Riverside Contracting, a Montana-based highway contractor, and I'm speaking today in opposition to SB 460. This bill creates redundant regulation as DEQ already has the ability to ensure water quality standards and DNRC has the ability to enforce water. Obtaining an open cut permit does not waive the requirement to obtain permits from other agencies. Currently, in the Open Cut Mining Reclamation Act, Title 82, Chapter 4, Part 4, Section 434, subsection 2J, an operator is required to comply with applicable federal, state, county, or local regulations, ordinances, and permits, licensing, and approvals for the operation. An open cut permit is not the end-all be-all when it comes to sand and gravel mining operations. Let the DEQ Water Quality Bureau continue to administer water protection as described in Title 75, Chapter 5. Let DNRC Water Resources continue to administer water quantity as described in Title 85. In addition to water resource issues, we obtain our air quality registrations and permits through the DEQ Air Quality Program and open cut permits in the DEQ Open Cut Mining Program. Adding redundant regulations like this, the Open Cut Act, to be administered by a program that does not have the experience and expertise similar to the Water Quality Bureau will only create confusion and inconsistency in its administration and interpretation as it was prior to the 21 legislation. Please vote no on Senate Bill 460, and I thank you for consideration.
Thank you. Further opponents online?
Mr. Chair, here's Joe Smith.
Go ahead, Mr. Smith.
Mr. Chairman, members of the committee, my name is Joe Smith, SMITH. I'm a regional environmental manager for Knife River, and I currently operate.
Mr. Smith, I think if you move a little closer, we could hear you better.
Just a little bit better?
Yes.
Okay. I just wanted to mirror the including HB 599 the subject matter expert for DNRC and contact. Water quality and we need to follow all state and local requirements. Thank you very much for your time, and I oppose this bill.
Thank you. Further proponents online?
Mr. Chair, that is all for opponents.
Informational witnesses.
Mr. Chairman, members of the committee, for the record, my name is Dan Walsh, W-A-L-S-H. I'm the Air, Energy, and Mining Division Administrator for DEQ. I'm also joined today by a couple of Mining Bureau staff, and our Water Quality Division Policy Analyst is online, and we're available for questions.
Thank you. Further informational witnesses.
Mr. Chairman, members of the committee, for the record, my name is Anna Pakenham Stevenson, spelled Pakenhamstevenson. I'm the Water Resources Division Administrator at DNRC. Happy to answer any questions that you might have.
Further informational witnesses? Do we have any informational witnesses online?
Mr. Chair, here's Eric Sivers.
Go ahead, Mr.
Yes,
Sivers.
Good afternoon. Thank you, Mr. Chair and members of the committee. My name is Eric Sivers. That's S-I-V-E-R-S, and I'm Montana DEQ's Water Quality Division Policy Analyst.
Any further informational witnesses online?
No, Mr. Chair.
Questions from the committee? Senator Gillespie.
Mr. Chair, could I try one with Anna?
Yes.
Pakenham.
Mr. Chair, Senator.
Yeah, Mr. Chair, Pakenham. I guess in our country we don't have the luxury of water up very close to the surface. It's all way down in the ground, if there is any. So help me understand on this deal. It sounds like people have very shallow wells they've been relying on forever and ever, probably generations. And now you come in and put in a big, deep mine. You can see where things go wrong real quick. How does that work? Who does have priority on a deal like that? First in line, first in time, first in line. How does that work?
Chairman Galton, Senator Gillespie, thank you for the question. Gravel pit mining operations are only required to obtain a water right if they intend to put the water to beneficial use. So say they're doing gravel washing. If they are not putting it to beneficial use sitting in the pit, they would not be getting a water right. To your question, who has priority date? If the gravel pit is required to get a water right and they are a junior, the senior water right holder would have priority.
Thank you.
Anna, if you'll just stay there for a second. My question for you is, I know your department measures water way more than the DEQ does, so have you ever seen any circumstances where you've seen a gravel pit dewater around it?
Chairman Gall, thank you for the question. We have not received any complaints to my knowledge right now, but that doesn't mean that we wouldn't or haven't. I'm just not aware of right now. Yeah.
Perfect. Then I have a question for Ms. Walsh. And feel free to re-refer this one. Okay. I was going to try with you before we go online. I have no doubt that you guys can handle the quality part of this. How comfortable do you feel handling the quantity part that they're asking you to cover?
Mr. Chairman, certainly where there's other expertise within state government, such as with DNRC, we would like to defer to those agencies that have that expertise. But if this were passed into law, we would figure out a way to implement that provision.
Thank you. Any further questions from the committee? Seeing none. Senator, would you like to close on your bill?
Thank you, Mr. Chair. Thanks for a good hearing. Yeah, just a couple of comments I want to respond to. One is the suggestion that this requirement for assessment of impacts related to water quality and quantity are redundant. In fact, when I talked to Department of Environmental Quality surrounding one particular proposal near Manhattan that was mentioned by Ms. Corbin, and I talked to DEQ and asked them about their assessment of water quality and quantity associated with the proposed gravel pit, and they said they could not consider that as part of their permitting decision. So I think it's misleading to suggest that that's already being handled somehow. In fact, it is not being handled. And I think it's fair to surrounding landowners that be part of the assessment. And that's the whole point of this bill. It is not happening now prior to permitting. I think I would refer Ms. Packenham Stevenson, who's not aware of any impacts related to water quantity, to a circumstance in the Gallatin Valley that I'm aware of where there was a water table that was at 8 feet or thereabouts, and it was sub-irrigating an alfalfa field, and after the gravel pit was installed, that water table dropped and is no longer sub-irrigating that alfalfa field. So it has had a direct impact on an adjacent landowner and their ability to raise a crop on their property. So I think that is a real impact. As far as the question regarding the reference to water quantity in this law, that reflects what was in the previous law prior to the change that was in 2021. So this is nothing new. And the expectation is that, correctly, DEQ is not the entity to administer water quantity, that is DNRC, but they could call on DNRC to do that as assessment as part of their permitting. So that's the answer to that. As you consider this bill, I'd ask you think about your own circumstances. How would you feel if you built a home, developed water on your home site, and then after years of improving your home, had a gravel pit develop in your backyard, and you have no recourse? This bill is about water quality, but I also have to mention there's other impacts associated with gravel pits that affect the values of homes. And there's a good reason why, as part of a real estate deal, you have to disclose whether you have a gravel pit nearby or one pending, because it affects values of your home. And I think that has to be a consideration as well. Certainly the effect on water quality is a big component of that. Thank you for the good hearing, and I ask for a due pass on Senate Bill 460. Thank you.
Thank you, Senator. That'll close the hearing on Senate Bill 460. And we will open the hearing on Senate Bill 472. Senate